Okay, good morning and welcome to our Wednesday morning seminar, where this morning we are joined by Richard Silver, Senior Partner, who's going to be talking to us about contractual and common law termination. As always, we do have some pre-submitted questions, but if there's anything that you'd like to ask Richard during the course of the seminar, you can use the either Q&A or chat tools in the bottom toolbar of your screens, your Zoom screens. And Richard will endeavour to get as many of these answered as he can. Again, if there's something specific you are having an issue with, or you don't wish to raise your question in an open forum, please feel free to contact Richard directly, Richard Silver at silverllp.com. His contact details are on the screen there, several places in the slides, and he's always happy to answer these questions for you. Without any further ado, I will hand over to Richard, who can start the proceedings. Richard.
Thank you, Julie. Good morning to you all. This morning we're going to deal with contractual and common law termination. As you will be aware, if you've attended any of my previous seminars, my background is in construction. I was a site agent, a site surveyor, chief surveyor and construction director, contracts manager, and various other roles. I've been involved in a lot of projects on site, and it's a shame to admit that not one of the projects I was involved with actually completed by the original completion date. On all the jobs I was involved in, for one reason or other, there were delays. And what generally happened was that the job would go behind. We would look internally and establish that some of the problems were our own and possibly caused by our subcontractors. And some of the reasons for delay may have been because of the employer or the employer's team, and for which we'd sought extensions of time. It was my experience that despite having sought extensions of time and the relevant 12-week period having elapsed under a JCT form, we still found ourselves not being granted extensions of time. And indeed, what generally happened was that the architect CA was asking for further and better particulars. We were often under tremendous risk of liquidated damages, and towards the latter part of the project, we're trying whatever we could do to try and complete the works. Now, we would go down on site and we would look at where available areas were, and we would look to get our subcontractors to deploy additional resources in an attempt to complete the job as quickly as possible and thereby avoid not only the liquidated damages, but our own prolongation costs. The problem was quite often the subcontractor was also, as far as they were concerned, in delay. In their view, no doubt, they felt that we were not awarding them extensions of time that they were entitled to. Because the job was behind, they'd always been out of sequence working with problems, so their productivity had reduced, so they weren't necessarily making money. And what they wanted, or what we wanted them to do, was to deploy additional resources to other areas, possibly further incurring them in losses. So they were less than keen to do so. So therefore, we were faced with a problem. We wanted to get the job complete as quickly as possible. Resources were not being deployed to site, and therefore we had to consider whether possibly to terminate the subcontractor's employment, or deploy additional resources to site, or to supplement their resources. And this is a common problem, because ultimately it ends up in a mess, and subcontractors and main contractors get into arguments of, was there a repudiation? Has there been a correct termination? And I can see that despite many years having passed since I was on site, these problems continue to occur. I'm a panel adjudicator, including on the RICS. I have 5 current matters that I'm instructed on, and I completed 2 decisions only recently, and 4 of them deal with or address the issue of whether there has been a correct termination. And looking through the papers before me, it seems to me that it is not uncommon for the scenario I've just mentioned to be one of the exact circumstances that has occurred. So what I'm going to look to do this morning is try to address the whole issue of termination, both under common law and under the provisions of the contract. And I'm going to deal with, first of all, the common law. Now, just to clarify that, any construction contract is subject to the common law. The common law is the law from precedent, case law. And what we're looking for is how contracts are going to be dealt with under English law. So the first thing is, and I'm sure many of you have heard of this, is that where there is a breach of a condition, as opposed to a warranty, the condition being a fundamental term, there has been a potential repudiation which the other party can elect to accept. So I just want to deal with this issue of condition and warranty. Under contracts, you obviously want a contractor to complete by a certain date. But generally, that is not considered a condition. In other words, their failure to complete by a particular date is not a breach of a fundamental term. Now, that often surprises people. But let's stand back and have a look at that. If a contractor finishes 1 minute late, they're still late. Should you be able to terminate before 1 minute? Well, that would seem completely unreasonable. What about an hour, a day, a week? Sooner or later, you would say, okay, enough is enough. I now think that the failure to complete within the time is a breach of a condition. But because it depends upon how extreme the failure is, we have what is called innominate terms. And an innominate term is a term that can either be a condition or a warranty, depending upon the circumstances. And that's the problem quite often in contracts. It is difficult to determine whether a particular breach is a condition, one entitling a party to terminate, or a warranty, one that doesn't entitle a person to terminate, but enables them to seek damages. And we're going to look at, first of all, those terms that the courts have determined are a condition, a fundamental obligation which would entitle a party to terminate. So, start off, a failure of the employer to give sufficient title to enable the work to be carried out. Clearly, if you're employed to undertake an element of works, but you simply can't undertake those works because the other party hasn't given you access to site, you're prevented from undertaking the works. Quite clearly, it is a fundamental failure. You are prevented from doing what you're required to do. You are not entitled to be paid because you haven't carried out the works. The whole contract has in effect been frustrated or failed. And as a consequence, that will constitute a fundamental breach entitling a person to terminate. Quite often, recognizing these potential problems, contracts do provide for deferment of access. But quite often, if that deferment of access to enable a contractor to carry out continues for a certain period of time, which shows that the contractor is being prevented from undertaking the works and that it's a fundamental breach, this will entitle the contractor, the innocent party, to terminate. Possibly even simpler is if a party says, we don't want you to carry out the works, then that will be a breach of a fundamental term. I've been employed to carry out some works. If you tell me you don't want me to do it, you're clearly undermining the whole contract. It's fundamental, and that will represent a repudiation. This top one is one that happens all too often. Where we have a contract and I have appointed you to undertake certain works, if I seek to employ someone else to do those works, then I'm preventing you to doing exactly what I've employed you to do. I'm undermining the whole contract. And therefore, that will be a repudiation. But it often happens, and many arguments are raised. So the first one that is often raised is, well, we've got the provision in the contract to omit. So all we've done is to omit certain elements of works, and then having omitted them, we've given them to somebody else. Well, very simply, Unless the contract allows for that, you can't do it. And to allow you to give the work to others, you've got to have a clause that says that it says along the lines of, we are entitled to omit works from your package at our absolute discretion and to give them to others. And it's this second part that's important. A requirement or a provision allowing you to omit will be read amongst the whole of the contract terms. And it will not be interpreted to mean to omit and give to others. It means to omit because we don't want them to be undertaken or we want to vary them. So if you want to omit and give to others, your contract has to provide for it. And if it does not, if you do seek to give it to other parties, then that will constitute a repudiation. Now, as far as contractors are concerned, one of the main concerns for them is payment. And unfortunately, and I can see it all the time, quite often when payment notices or payless notices aren't issued and the contractor is entitled to the amount that they've applied for, it's not uncommon that the employer isn't overly pleased and will nevertheless decide not to pay. But simply a failure to pay is not a breach of a condition. What it is showing is there is a dispute as to entitlement to payment, not that the employer necessarily wants to bring the contract to an end. So when one is looking at a failure to pay, one needs to look at how long this has been going on and when in the contract has it happened. If it's happened at the beginning, it is less likely to evince an intention to bring the contract to an end. If it moves toward the end, it is more likely to be persuasive that it is repudiatory conduct. But as you can see on the second point, there has been situations where the courts have determined there was no intention to bring the contract to an end, despite the employer not having to pay 3 installments. So if you're subcontractors, I'm aware, all too often contractors don't pay you what you think you're entitled to, but nevertheless seek to get you to provide to site more and more resources. Simply this failure to pay will not entitle you to terminate the contract. The next one at the bottom of the page is the abandonment of the site. Under the contract, we now have provisions for the issue of notice of intention to suspend. And the way that they work is that if a party fails to pay the amount due by the final date for payment, the other party is, following the final date of payment having elapsed, being entitled to issue a 7-day notice of intention to suspend. If following that notice and the 7 days, payment is still not paid, then the innocent party is entitled to suspend all or part of its works. But only, and I underline only, under those circumstances is a party entitled to suspend. So it's quite onerous to follow these provisions in order to allow you to suspend. Because quite often payment and payless notices have been issued, which show that the amount due is, whilst less than what you've applied, is a sum which has been paid. Or indeed, you may have the situation that because the payless notice has been issued, no monies are due. You are there in great danger if you then seek to suspend following such payless notices. What you would need to establish was that that payless notice was wrong, that monies were due to you, and that they obviously were not paid by the final date for payment. But turning back to the notice of intention to suspend, I have seen various notices, and unfortunately, more often than not, they are not compliant. So you have to be very careful. The first thing you must determine is what was the final date for payment. And I'm only too aware that under some subcontracts, that's not an easy process. Indeed, under many main contracts, what you often find is that the interim payment mechanism is varied. Because as the project goes, someone goes on holiday, the PQS, and says, well, let's do it slightly later. Or there's an application made that the employer says, well, I'm not really happy with the amount of information, so provide me more information, and we defer the payment mechanism and we'll consider that further information. And what happens is the due dates and final dates get confused and blurred. But what you're going to have to do if you're going to seek to suspend is first of all establish what the final date for payment is. Once you've done that, tick box 1. You then need to establish quite clearly that you have not been paid the amount properly due, which will be the amount that you've applied for if the other party has not issued a payment or pay less notice, and your application therefore becomes the notified sum. You'll need to look at any payment and pay less notices to see whether they're issued in due time and or were compliant. Having established that the final date of payment has elapsed and the amount due has not been paid, you've got to issue a 7-day notice, not 6, not 5, but 7. So within the notice, you must state 7 days, which is our intention to suspend, and then you must wait the full 7 days. You could have done everything correctly, but if you suspend after day 6, you will have committed a repudiatory breach. So vitally important that you issue the right notices at the right time. The next one is the one that all too often happens. As I went through at the beginning, it's not uncommon during the latter parts of the project where the project is behind for the contractor to put tremendous pressure on the subcontractor to complete the works as soon as possible. And the question is what are the subcontractor's obligations? Now, it is often the case that incorporated within the contract is a program. And quite often within the subcontract, there is also an obligation to act with due skill and care and due diligence. But it is also very often the case that those contractual provisions aren't clear when one looks at the whole of the contract. It's my experience that in the majority of subcontracts, because of the way they are drafted, the subcontractor has a right to carry out the works in any sequence it chooses. It is also entitled to complete the works late, because the contract indeed provides for liquidated damages or general damages for late completion. It's thereby recognising that might happen and what is the consequence. Now, as far as these programs incorporated, if you want to have control over the subcontractor, you need to make sure that the program is properly incorporated into the contract and the contractual provisions and the program are matching. So, for example, you should include, like the old DOM forms, the JCT forms, that it says that you should carry out the works as per the contract program. But you also need to say that, for example, for each activity, you shall start following the issue of a notice, and that notice will be in a window of 12 weeks, and that you need to complete that activity within 10 weeks. And you also need to provide for extensions of time for each and every one of those activities. Because do remember, when you include a program, how often do you follow it? If you issue to a subcontractor a program, and let's just say, for example, that it has 12 bars on it. And bar 1, they start on time and finish on time. But bar 2, because of a few problems that you've got, starts a week late. Well, do they still have to complete by the same completion date by that bar, despite the fact it was your failure? Well, the answer will be no, because that will be a penalty clause. You would effectively be benefiting from your own breach. You would be seeking damages for the late completion of that activity because you had delayed the start. So to overcome that, you need an extension of time provision. So you need an extension of time provision, not for the end date of the subcontract, but the end date of that activity. And therefore your contract must provide for extensions of time for each and every activity. Now, if you want to say that the extension of time, or there is no extension of time for late access to commence a particular activity, what you need to do is to have provisions in the contract that stipulate a window to the start of each and every activity, and then the issue of a notice for each and every activity. As you can see, that subcontract is going to have to be very carefully drafted. And it is quite the opposite of the way the NEC is drafted, by way of example. So if you're under an NEC subcontract, you're going to need quite a few amendments, because under the NEC, the obligation to issue a program is upon the subcontractor. What you can do to try and overcome this is to have each and every activity as a separate section, but that creates its own problems as well, or possibly a key date, but that's going to create further problems. So be aware that under most contracts, particularly subcontracts, there is simply an obligation to start by the start date and complete by the completion date, and it's up to the subcontractor or the contractor under a main contract to determine the sequence in which they undertake their works. Which then raises the issue that, well, when will a contractor or a subcontractor have failed to proceed with due diligence? What you're going to be looking at is the particular program that has been issued to monitor against. But if you're at the beginning of the works, it is more unlikely to be seen that there has been a breach of a fundamental term if they're falling behind, because there is obviously a lot of period of time left in which that time can be caught up. As you move towards the end of the project, you can see the amount of work that is left. You can look at the amount of resources that are available on site, and therefore you're going to be more able to substantiate if they're proceeding with due diligence or not. Clearly, the easiest time to argue that there has been a failure is post the completion date, when the subcontractor or contractor should have completed, because clearly they have fallen behind, they haven't met their obligation. But what you're going to have to look at is the amount of resources that are on site and what they're doing. And as we've identified earlier, simply the fact they've failed to complete by the completion date does not generally entitle you to terminate. So do be careful. Just looking at it, on the third point, the fact that we've got, for example, that time is of the essence, which is meant to mean that time is fundamental, is going to be contrary to other provisions where there are extension of time provisions and also the potential for either general or liquidated damages. In one breath, we've said that time is of the essence, and in other words, you must complete by the completion date or this contract will be brought to an end. But then you've got other provisions that says, but if you don't complete by the completion date, you may be entitled to extensions of time and you may have liability to damages. Well, that's at odds with time being of the essence. And therefore, the courts will interpret that whilst the term of the essence is used, it is not a condition of the contract. Okay, the next bullet point, bottom of the page, is a failure to remedy defective works and which delays following trades. What the courts look at is if there is defective work, the contractor is obliged to rectify it, and they have what is a reasonable period of time to undertake it. If they fail to do that within a reasonable period of time, that will be considered a breach of a condition. But you must have notified. So, in circumstances, it's quite often towards the end of the job that there are defects that are preventing completion. If you are concerned about the ability of the subcontractor or the contractor to complete these defects, the first thing is to notify them. I would strongly suggest possibly giving them a period of time in which to rectify and also asking them to provide the necessary method statements and the like. If after a reasonable period of time they have failed to do so, then that will be considered a breach of a condition, entitling you to terminate. So the first example was where there is a breach of a condition, where there is a fundamental breach which enables you to terminate, and we've given you some examples. But the second situation is not where there is one breach, but there is so many of them that when one considers all of them, they evince an intention that the guilty party either doesn't want to complete the works or is simply incapable of completing the works. This is always going to be difficult because how many breaches are there necessary to evidence this failure by the guilty party? There may be no end of health and safety problems, scaffolding being used without the necessary paperwork in place, completion of works that are quite clearly defective, breaching other rules. What one's got to look at is whether that contractor, when one considers all these failures, is actually able to carry out the works. And what I would suggest that you strongly need to do is to record all of those failures and your request that they rectify them. What you also need to ensure is that your request is both reasonable and the obligation you're placing on the other party is in accordance with the terms of the contract. So I've been involved in many projects where towards the latter part of the job, one particular trade is just incapable of carrying out the works. They are so terrible. Their people are breaching no end of rules that are required, and they are breaching health and safety, going onto scaffold when they are not allowed to, adapting the scaffold when they're not required to, damaging other subcontractors' works. What I would suggest you do in those circumstances is A, take photographs to evidence it, record it, give them an initial warning, and then if that continues, then you are likely to be able to terminate under this provision. The next example is where a party informs the other party that it no longer wants to carry out the works. This is, as the bottom of the slide says, an anticipatory breach. So let's give you an example. Let's just say that at the beginning of the contract, you've sent out some invitations to tender, you've received a quote back, and you've accepted it. You've got a contract. What then happens is the subcontractor who submitted the quote finds there's a fundamental failure in their quote. They've underpriced it for whatever reason. They don't want to do the job. They therefore tell you they don't want to do it. That would be an anticipatory breach. There is a contract in place. They have an obligation to undertake those works. They've advised you that they do not want to. It is an anticipatory breach, which you can elect to accept and thereafter seek damages for breach. Now, as I dealt with at the beginning, we have the situation that you can terminate where there is a breach of a condition, but not a breach of a warranty, and that there are certain terms that are innominate or intermediate terms, which may be a warranty or may be a condition. This creates some difficulties. And therefore, to overcome this problem, quite often contracts include express provisions for termination. Both JCT and NEC do this. But it is important to understand that the provisions in the contract do not bring the contract to an end. It is only likely to bring the end of the employment of the contractor to an end, but the provisions of the contract continue to apply, and indeed quite often have detailed provisions of what happens following the termination. For example, under JCT, where the contractor's employment has been terminated, no further monies fall due to the contractor until the end of the making good defects period. So quite often there will be a benefit under the contract for terminating under the contract rather than at common law. Now, within those provisions, there may be a whole list of circumstances that you may be able to terminate on. including failure to pay. Now, provided those provisions are not at odds with other provisions in that contract, and obviously JCT and NEC are fully compliant, then you will be unable to terminate under those provisions as well as under the common law. As I have said, and just to emphasize, all terms need to be read in the whole, in consideration of the whole of the contract. Simply saying that something can be a condition doesn't by itself mean it is as a condition. I've seen subcontracts drafted by contractors, which, no surprise, can be extremely onerous. And I've seen a clause, for example, that any breach of these terms shall be considered a condition and will entitle the contractor to terminate. Well, that's hugely onerous. So onerous, and almost certainly will be in conflict with other terms. For example, if it says you fail to complete by the completion date, we can recover damages from you. Well, that's in conflict because it says in one breath, if you fail to complete by the completion date, we can terminate. By another term, though, if you fail to complete by the completion date, you may have a liability for damages. There's inconsistencies here. So generally a clause that says any provision of this contract, if breached, will be a breach of a condition is unlikely to be successful. The next thing is that most contracts, unless they expressly state otherwise, are in addition to your common law rights. So in other words, under most contracts, not only will you be able to terminate under the express provisions within the contract, you can also terminate under the common law. So under JCT, there is an express provision that actually says that your common law rights are retained. So it is clear under the JCT, you both have the rights to terminate under the express provisions, but also under the common law. However, that is not the case under the NEC. The NEC says these are the parties' only rights, and therefore, arguably, there is no common law right to terminate under the NEC. Now, why would you choose to terminate under the common law rather than under the contract? There can be a number of reasons. The first thing is under the contract, there is generally a benefit to the innocent party to terminate under the terms of the contract, because you can rely upon the provisions that apply post the termination, and which quite often include provisions such as that no further payment will fall due to the guilty party until the end of the making good defect period, that you may be able to use all their plant and machinery on site. Those are going to be to your benefit. However, under the common law, you're bringing the contract to an end there and then. And as a consequence, the payment provisions disappear. And any monies that were due to the contractor, if you've terminated under the common law, would be payable. So you would think straight away that the only time you should, or you should only be terminating under the contract, not at common law. But under common law, there is no requirement to issue notices. Time might often be the most important factor. You want to bring the matter to an end now so that you can employ someone else tomorrow. If you go through the contract mechanism, you have to issue a notice today and maybe a second notice in 2 weeks' time. That can be difficult. You may not have the time to wait, and it's on that basis that you may choose to terminate under the common law rather than under the contract. So what's the circumstances, or what happens following termination under the common law? Well, very simply, the contract has been brought to an end. So what we've got to decide or to look at is how that termination occurs, because the first step is that there is a breach of a condition, a repudiation, And then the other party has an option. They have an option either to elect to affirm the contract, and which means that that contract is not brought to an end, or to accept the repudiation and bring the contract to an end. So there is a choice. Just going to give you an example of a case. What happened was there was a boxing match. And prior to the boxing match, a printer was employed to produce posters and the like for the match. Following the placement of the order, however, the boxer broke his hand, and therefore the match was postponed. The promoter contacted the printer and said, "Thanks, but we don't want any of the posters any longer." However, the agreement had no provisions for termination, and on that basis, what the promoter had done was to commit a repudiation. They'd advised that they no longer wanted to be bound by the contract and they didn't want the posters. What the printer had was an option. He could either elect to accept the repudiation and bring the contract to an end, or alternatively to affirm the contract. In this particular case, the printer affirmed the contract, said, "I'm still going to produce them and issue them to you, and I want full payment." The matter went to court, and the promoter argued, "Well, I told him not to produce it." Court said, "Well, you didn't have that right. What you'd done was you committed a breach. The printer had the right either to elect to affirm the contract or to accept the repudiation. He affirmed the contract, and now you have to pay for all the posters." There needs to be clear and prompt election. So the innocent party must respond within a reasonable period of time, and he must clearly show what he intends to do, either to affirm the contract or elect to accept the repudiation. In order to affirm the contract, he has to have, first of all, the knowledge of the breach, and also his legal right to choose. In other words, you cannot elect one way or another until you actually know of your rights. So far as affirmation is concerned, it can either be expressed or implied. So in other words, you can state it orally to a party or write and confirm, or you can do something by your actions which indicates that you've either elected to affirm or to accept the repudiation. The fact that one party, however, simply asks the other party to carry out their contractual obligations does not mean that they've elected to accept or to affirm the contract. All they're doing is what they're entitled to do under the contract. They may still be considering which option, or may be looking to see whether the other party will actually carry out the works and thereby decide not to bring the contract to an end. So simply requesting the works to be carried out is not a choice between bringing the contract to an end or affirming the contract. Simply doing nothing will not be an election. And the fact that time goes on does not mean that a party cannot later on elect to accept the repudiation. And possibly it may be a week or a number of weeks since it's happened. However, where other parties have changed their position because there hasn't been an acceptance of the repudiation, the right to terminate may have been lost. This is the issue that all too often happens. Where a party seeks to terminate and issues the necessary paperwork, the other party says, "But we weren't in breach, but you are now by issuing this notice. So we elect to accept the repudiation and we say we've terminated." So both parties are arguing that the other party committed the repudiation. Now, quite often, both parties have committed a repudiation. It may be the case that one party has failed to pay certain amounts and was also brought in other subcontractors and seeking to supplement. One party has then initially sought to suspend the works and has then thereafter maybe said, well, in fact, we think there's been a repudiation. The first party then says, but you suspended the works without notice, so you repudiated. And the general rule is whichever party committed the repudiation first, that party will be held responsible if the other party then elects to accept the repudiation. So it will be the first person who repudiated will be found to be, the other party will be found to be the innocent party. So it is quite important to therefore look at correspondence. Now, a prime example of this is, I've seen a situation where a contractor has issued initial notice to terminate, and there's a second notice to be issued 7 days later. But prior to the 7 days later having occurred, they've then brought on resources onto site. Now, they may well have had a right to terminate, but they've brought the other resources onto site too early. They have therefore committed the repudiation, and the other party has a right to terminate. Where there has been a termination, there is two consequences. First consequence is that the party, the innocent party, will be entitled to damages. They're entitled to be paid damages to put them back into the position they would have been, but for the other party's breach. The second thing they will have is effectively they no longer have any obligation to carry out any works under that contract, and which would include, for example, the making good of defective works, because the contract's been brought to an end. So two outcomes of a termination following a repudiation is that a party is entitled to damages and they have no longer any obligation to carry out and to complete the works, and which would include completing outstanding defects. Now, what's the significance of that? Well, if that has occurred, in determining what a contractor is entitled to be paid, we cannot generally seek to recover the cost of rectifying defects. What we would instead do is seek to abate the value. So let's give an example. Contractor has built on site, amongst many other things, a wall. The employer then commits a repudiatory breach, which the contractor elects to accept. Now, the wall as built needs to be knocked down and rebuilt, and therefore the cost is greater than the wall itself. It may be that the cost of building the wall, the contractor would have been entitled, let's just say, to £100, but in order to knock it down, remove all the bricks and rebuild it would cost £150. Because there's been a termination, there's an abatement. So the maximum the abatement can be applied is £100. We don't pay him for the wall. What we cannot seek to recover is the cost of rectifying the defects, because he no longer has that obligation, because the contract has been terminated. Important point, however, is that any rights acquired before the termination are retained. And again, this is one that often comes up before me in adjudication about certain interim payments. There's been a number of interim payment notices and amounts due, final dates for payment having elapsed, but then there's a termination. If those payment provisions provide for payment, it is likely if those rights for those payments occurred pre the termination, then those monies are still obliged to be paid. Quite often people say that where the contract is terminated, it must have disappeared. There is no contract, and therefore there is no right to adjudication or arbitration. That is not correct. Adjudication and arbitration clauses are retained following the termination, and indeed, it is quite often the case that during the process of the adjudication, The issue of termination is the dispute that is referred. Under many construction contracts, including JCT, the contracts often say that notices of termination shall not be given unreasonably or vexatiously. And as at the bottom, the term vexatiously was held to connote an ulterior motive to oppress, harass, or annoy. I would suggest to you that quite often when the contract is terminated 2 days before completion, then there is a distinct danger that such termination will be vexatious. I have seen it quite often that employers have terminated when the works are virtually seconds away for completion. And the reason that the employer has done it, not only to annoy the contractor, but also because they think they therefore can avoid payment for a considerable period of time and possibly till after the making good of defects period. They can't, because it will be determined that the termination was vexatious. As I mentioned earlier, where it says in a contract, and the JCT is an example, without prejudice to any other rights and remedies, this is a reference to the common law rights being retained. Now, where we have provisions in standard clauses, in standard forms for termination, let me just impress upon you the vital importance that you comply with the notice requirements stipulated in the contract. And there's two things that the contracts quite often do. A, they set down when and how notices are to be issued. And they also stipulate under what grounds and what is to be stated in the notice. So if the notice says that you are to issue a notice and that within 7 days, after 7 days thereafter, you can issue the second, make sure you wait until after the seventh day. If it says that you are to issue the notices by recorded delivery to a certain address, make sure you do it. Where there is a second notice, it generally has to be seen linked to the first notice. So where you've issued the first notice today, don't issue the second notice 2 years later. You would be better placed to issue the first notice again and then the second notice. Now, there's a lot of case law and there are circumstances where parties have got away in not strictly complying with the notice requirements, but not where they haven't allowed the period of time between the two notices to elapse. And indeed, on one of the first projects I was involved in, we had a situation where the bricklayer, this is when I was an assistant site QS, the bricklayer had not performed particularly well. And it was quite clear that we had a right to terminate under the subcontract, but the contracts manager didn't issue the two notices in the right format, nor at the right time. As a consequence, there was a big dispute and it all went off to litigation. We had no end of expert reports showing how the works were clearly wrong, that there clearly had been a breach by the contractor, but the fact that we had not given them a proper opportunity to rectify and that we had not issued the notices when we should have done, it was found that we'd committed a repudiatory breach, which the contractor had an entitlement to accept, which it had indeed done. And we ended up paying damages despite the works having been terrible. It is on this basis that where a party seeks to terminate where they didn't have a right to do so, it will generally be seen that they themselves have committed a repudiation. Where there is an argument of which party repudiated first, you can raise a new reason looking retrospectively that maybe at the time you didn't know of. So if you can find something subsequently, both parties have terminated, it's a question of which party repudiated first. If you find new evidence, for example, let's just say that you find evidence that before you wrongfully suspended, that the contractor had actually met with another contractor and employed them to undertake your works, you could rely upon that even though at the time you didn't know it. You would show that the contractor had employed others before you'd wrongfully suspended, and therefore you would win the argument that they had repudiated first. There's one final thing that I will raise that often is not considered, is the issue of liquidated damages. We have a contract, the completion date has elapsed, the job's not going particularly well, and the employer seeks to terminate. They're now going to take 6 months to complete the outstanding works. What happens to the provision for liquidated damages? Clearly, the employer can claim liquidated damages up to the termination, but what about the 6 months it takes the employer to complete the works? This was considered in a case concerning triple point. It's called the triple point. And what the court said is it will depend upon the particular contract. And where the contract says that you can claim liquidated damages from the date the work should have been completed up to the date that the contractor actually completed, there is a problem because you have terminated and therefore the contractor will never complete. And therefore, in theory, you're entitled to damages forever. That would then be a penalty clause and would fail. So what you would need to do is to say that the damages will run from the date that the work should have been completed to the date that the contractor completes, or where there has been a termination where the alternative contractor completes or should have completed within a reasonable period of time. So do be careful. It is my view that the standard JCT form is, for example, going to have problems on this point. Okay, thank you. Julie, are there any questions?
You are indeed, and some of this you've covered, but just to clarify, what is the position of a main contractor who places a subcontractor on notice of termination for suspending the works, and the subcontractor then places a token resource on site? One, has the subcontractor done enough to avoid termination of contract? And two, must the main contractor then set in process a new case to demonstrate that the works are now adequately resourced rather than suspended?
It would depend upon the contract. If the contract provides that you have to issue 2 notices, that you have to first notify the contractor, and then if he fails to rectify the breach, you can then terminate, which I think is the example that is being given. The fact is following putting on a token amount of staff, it may well be seen that it has no longer suspended. So what the courts would do, an adjudicator would do, is to see whether the works continue to be suspended. Now, if there's just a man and his dog being there for 10 minutes, I would suggest that the works or elements of them have still been suspended. But if they've deployed to site 5 or 6 people, you wanted 20, I still think that they are no longer suspended. So you would have to start a new process, maybe seeking to argue that they're failing to proceed regularly and diligently. So in simple answer, a party can avoid termination of an alleged suspension by putting on some resources, even if it is not sufficient to meet the innocent party's requirements.
Right, but one man and his dog is just not enough.
One man and a dog is unlikely to be enough on a 20 million project, but it might be okay if all he's doing is a mastic around your kitchen sink.
Okay, point taken, thank you. Right, that appears to be the only question so far, unless anyone else has any questions for Richard. As we said before, do not hesitate to contact him directly if you have a specific query about one of your current projects. Richard Silver at silverllp.com. Next week we have extensions of time and proving delay, which is being presented by Conor Ahern. So if you haven't yet booked up for that, then please do so. Email us at seminars@silverllp.com. So in the meantime, thank you, Richard, for your time this morning. Thank you to everyone for attending. Is there one last minute question coming in there? No, that's a thank you. So you've obviously explained everything fabulously, Richard. Thank you very much indeed. And we look forward to seeing you all again soon. Thank you all. Bye-bye.
Thank you.